Hello viewers, welcome to my YouTube channel. A dental college in Rajasthan allowed admission for 16 MDS students in 2017 without NEET qualification. The Honorable High Court of Rajasthan refused to regularize these admissions and ordered a compensation of Rs 10 lakhs to each student. This is the important court judgment released recently. We will look into the details of the court order. Dental college admits 16 aspirants without NEET. Rajasthan High Court refuses to regularize admissions, orders Rs 10 lakh compensation each. The Rajasthan High Court has refused to regularize the admissions of 16 medical aspirants who were admitted to a dental college in Kota without qualifying the NEET examination. It, however, granted Rs 10 lakh compensation to each student, stating that the college has made a false promise assuring them a seat in MDS course. The court also directed the Vice Chancellor of the respondent Rajasthan University of Health Sciences to initiate disciplinary proceedings against the erring officials who had handed over degrees of the petitioner students despite an order of the court to withhold the same. The fact remains that the petitioners were admitted in the course in the year 2017. And their 3 years in the college is sheer wastage of energy, time and money spent on their education by their parents. This court, though, cannot regularize the admissions which were granted to the petitioners. However, the petitioners need to be compensated in the respondent college by the respondent college for the illegality committed by them while giving admission to the petitioners and further furnishing incorrect and false information to different authorities, that is, Respondent University and Respondent Dental Council of India. Background: the 16 petitioners were admitted in MDS course in the Respondent College in May 2017. As per information booklet, a candidate was to obtain a minimum qualifying score. However, petitioners did not secure the requisite cut-off marks in NEET PG examination 2017 and were granted admission by the college after the mop-up round was over. Moreover, all the petitioners were not found to be qualified as per the scorecards issued by the National Board of Examinations. The enrollment forms filled in by the petitioners in the university reflected the marks of the petitioners, and the same were at variance difference as per the record available with the NEET PG admission board. Later, the respondent college uploaded the list of the students admitted in the MDS course on the Dental Council of India's web portal and was subsequently ordered to discharge 16 students who were admitted illegally in the MDS course in the year 2017. However, the respondent college permitted the students to undertake the course and did not challenge the said orders. Under the aforesaid circumstances, the petitioners pleaded that in spite of completing 3-year course of their study, the denial of the respondent university to issue enrollment number and preventing the petitioners to participate in the examination was an arbitrary act, and as such the petitioners filed the writ petition praying for direction to allow them to fill online examination forms and to participate in MDS final year main examination to be held in the year June 2020. Notably, after the judgment was initially reserved on 19/4/2022, the respondent university had sent the degrees of 16 students petitioners of MDS batch 2017 to the respondent college and the said degrees were distributed to the petitioners from 2522 to 3522. Court observation. The court noted that some of the petitioners did not even appear in the NEET PG examinations 2017, and yet, while filling up the enrollment form, they all have shown themselves to have appeared in the NEET PG examination 17, and some of them also gave incorrect information relating to the marks obtained by them in the NEET PG examination. By supplying incorrect information to the university authorities and by furnishing false information of having secured qualifying marks in the NEET, the petitioners cannot be allowed to plead that notice or opportunity was required to be given to them, added the court. It was observed by the court that petitioners got admission by wrong means, knowing fully well about their eligibility, and as such they cannot be permitted to claim right in their favor of offering them opportunity of hearing before discharging them from the course. In such they got admission in an illegal manner. Further, the court refused the petitioners at submission that seats in medical courses should not go waste and admission given to the candidates may be regularized. In this regard, the court opined that if the submission is accepted, then college admission bodies will be acting on their own to adjudge the eligibility of different persons for the professional courses, and the candidates without having the requisite eligibility and merit will be able to get admission, and then seal of approval will be sought from the courts of law that such persons need to be regularized for the purpose of pursuing professional courses. Reliance was placed by the court on one case wherein Apex Court had laid down the law that if the admissions in the medical colleges are granted by conducting private counseling, then such admissions are termed as per se illegal. The Apex Court had further held that when the admissions granted to the students through private counseling are found to be per se illegal, then such admissions cannot be protected as the said admissions were done in a patently illegal manner. The court observed that admissions of the petitioners by illegal means cannot be retained. The court noted the Apex Court order in one case had considered the issue of admission by illegal means, and such wrongs were not allowed to be retained by an appeal to the sympathy of the court. The court opined that university authorities who have issued the degrees to the respondent college have acted in the most irresponsible, callous and illegal manner. The fact of restraint order being passed by the division bench of the court was very much in the knowledge of the university authorities, and in spite of having the knowledge of such restraint order, if they have handed over the degrees of the petitioners to the respondent college, they need to be dealt with by the court in strict manner, added the court. Furthermore, the court added that their explanation by terming such action to be a human error, and further only by giving letter of calling upon explanations from two subordinate staff, that is, section officer and senior assistant, is no solution answer to the blunder committed by the university authorities. The court also observed, this court is also required to see the conduct of the respondent dental college as in what manner admissions were granted by them to the petitioners, and further in spite of the discharge order passed by the DCI in the year 2018, yet the petitioners were allowed to continue with their studies by permitting them to complete 3-year MDS course, apparently made them eligible for claiming relief of appearing in the examination on completion of 3 years. This is the full details of the court order. It is very clear that candidates admitted without NEET qualification in no way protected by the court orders. Thanks for watching. For updates, subscribe to my YouTube channel. Thank you.